Welcome to Law School for Journalists. Thanks for coming. We're looking today at the insanity plea and the death penalty, and also public access issues. And our guest speakers today are Karen Steinhauser and Steve Zansberg. I'd like to formally introduce them. Karen Steinhauser practices at Steinhauser Law, handling criminal defense and high-conflict family law cases. Before private practice, she served in the Denver District Attorney's Office as Deputy and Chief Deputy District Attorney from 1981 to 2001. As a prosecutor, she tried more than 250 cases and has served as a full-time law professor and as adjunct professor at the University of Denver Sturm College of Law since 1990. Also as faculty member for the National Institute of Trial Advocacy since 1992. Steve Zansberg is a partner with Levine, Sullivan, Cook, and Schultz. For more than 15 years, he's represented media companies, online publishers, and individuals in defending claims based upon content, fighting subpoenas, and seeking access to government information and proceedings. Most recently, he represented the national news media in connection with coverage of the Aurora Theater shooting case. With that, Ms. Steinhauser, thanks.
Let me just start by asking how many of you were here last time that we did this in August? Well, as you can see, we've come a long way. We still are at the point where we suspect that he may be entering a plea of not guilty by reason of insanity, right? So, and again, I wanted to just kind of make the caveat that even though I do media commentary and I'm up here, that I do have no inside track, and oftentimes do get my information from you all. So. With that, so I'm going to be talking about just the procedural issues with regard to insanity and then death penalty. But in terms of questions, if you all have any questions outside that, I'm happy to take them. So, and I want to start with just kind of historically this whole insanity statute, and because I know you've seen so many motions and everything addressing that. Before 1995, with regard to the insanity law, we had basically a statute that provided for two separate trials. So before 1995, if somebody pled not guilty by reason of insanity, there was an insanity trial. And then if a person was found sane, then there would be a separate trial in front of a separate jury. So the jury never got to hear all of the information that came from the sanity piece. So in 1999, the procedure changed, or 1995 rather, whereby there was just one trial, one jury that would make a determination both as to the sanity issue, and insanity was treated as any other affirmative defense, as well as guilt or innocence. So, things kind of got muddied a little bit because under the insanity statute, the jury can only consider certain information as it pertains to the issue of sanity and not trial of the merits. So, all these questions arise is how can the jury do that in terms of separating out what information they can look at for sanity versus deliberation, intent, those types of issues. The other change that got made is in 1999, there was an addition added with regard to this issue of non-cooperation. And the idea that with non-cooperation then, the defense could not call witnesses at the trial to talk about the issue of mental health condition, the sanity of their client. But the big issue is in 1999, this whole, and I call it kind of punishment for non-cooperation, was added as it relates to a death penalty sentencing. And so in 1999, we saw this piece get added that said if a defendant doesn't cooperate during a sanity evaluation, then they cannot call witnesses to testify about mental condition, sanity, at a death penalty sentencing. And I will tell you that because it was 1999, we have not seen any death penalty cases where sanity was the issue, where sanity was raised. So there's no case law in terms of this issue of can you really punish somebody with regard to not cooperating in a sanity exam by saying you can't call witnesses in a mitigation phase when the jury is deciding whether you live or die. So that's what's causing a lot of angst, I think, on the part of the defense and on the part of us trying to figure out, I don't know if this is constitutional. So, and the judge won't address it, of course, because there was no death penalty in front of him at that point. So that's kind of historically where some of these issues. I want to talk about also, and there's some slides here, I'm kind of going out of order, but there's been a lot of issues raised about this narcoanalytic interview and that the doctors can give truth serum polygraphs. I just want to tell you that has been in the sanity statutes for probably back to the 60s, 70s. This is not something new. It was not something that's added. And with regard to the advisement, I don't believe that the judge gave an advisement different than a judge would for any other defendant who's raising the issue of sanity. Basically, the judge has to advise all of the things that are in the statute. So it has been there for many, many years in terms of the ability of doctors to use truth serum, as that's referred to. I think we think about more in terms of TV shows and how that gets used and polygraphs. So that's not anything new. But let's just kind of start with how this whole insanity gets started. The applicable test for insanity, and I think you all were sent the PowerPoint, but what we're talking about is a person who is so diseased or defective in mind at the time of the commission of the act. So that's the first piece. Does the person suffer from a disease or defect that basically renders them incapable of distinguishing right from wrong as to the act charge? So it's a couple things with that. We're looking for, is it a disease or defect? And we're talking about at the time of the crime. Now, when we're talking about the time of the crime, we're not just saying on that particular day. Right? So, a lot of people say, well, but look at all his actions leading up to it. A person can be insane and still be ordering things off the internet, can still be making plans, all those types of things. So a doctor isn't going to be looking at the specific day that the shootings happened. They're going to be looking at, kind of this whole time frame. But we're not looking at, is he insane today? So we are going back in time. And insanity is distinguished from the issue of competency, where we're talking about, is somebody able to assist the attorney in their own defense? Do they understand what's going on? The issue of competence can be raised at any point in time by any of the parties, by the prosecution, defense, by the judge. We could be in the middle of trial, and the issue of competence could be raised. Insanity has to be raised at the arraignment. Now, for good cause shown, the judge can allow the addition of not guilty by reason of insanity, and in this case, the judge did indicate that he would entertain a plea by a request for a plea to enter of not guilty by reason of insanity at a later time. The other piece that's part of the evaluation is the second part, where we're looking for a condition of mind caused by a mental disease or defect that prevented a person from being able to form the specific intent that's required, that has to be proven as part of a crime. So when we're talking about specific intent in this context, we're talking about the intent to commit a crime, as well as the after deliberation. So there's two different parts to that. The insanity, in terms of a finding of insanity, that basically takes away any accountability by an individual for persons found insane. If the issue is a condition that causes a person not to be able to form a specific intent, that is not that doesn't take away total accountability, but it could reduce certain charges from, say, a first-degree murder or first-degree assault to something lesser. And then, I go through, and you have it in the PowerPoint, what the definitions are of disease or defective in mind. And remember, what we're talking about in the statute makes it really clear that it doesn't refer to any kind of abnormality that just manifests itself in repeated criminal or antisocial conduct. So the statutes are real clear that we're separating that out. I mean, we may see antisocial behaviors, we may see all kinds of different, what we call DSM-3, DSM-4, that people, that somebody may have, but that's not necessarily the definition of insanity.
In the previous slide, how do you prove intent in his case, for instance? I mean, or the lack of intent, because everything to the naked eye, not an expert or an attorney for a deed, for instance, you can see intent leading up to it. It was obvious in the preliminary hearing. So how does his attorney prove otherwise?
Well, his attorney doesn't have to prove anything. Right? Keep in mind that the defense has to prove intent, and the defense has to prove that. The prosecution has. Thank you. Prosecution has to prove intent. Prosecution has to prove that he's sane once the issue of insanity gets raised. Again, this is going to come down to doctors and other experts who are going to be giving opinions with regard to the issue of intent. And the prosecution will be able to call doctors, defense will be able to call doctors, and that's what it's going to be centered around is, again, what if he does have a disease or defect or some other condition of mind that interferes with his ability to form the intent.
Would that be he did not intend to kill? What would the defense be then?
Well, the defense would still be that he suffers from, say, what's called an impaired mental condition that makes it so that whatever is going on, whatever that abnormality is, that he cannot form the specific intent. It interferes with his ability to be able to do that.
In other words, he did not know right from wrong?
Well, the right from wrong, it's two different things. If he's incapable of distinguishing right from wrong, that's the insanity defense. The impaired mental condition has to do more with it doesn't rise to the level of not being able to distinguish right from wrong, but again interferes with his ability to be able to form specific intent, whether it's to kill, whether it's to maim, and again, it's all things that the professionals, the experts, are going to have to be talking about. I mean, it's going to be, lawyers can't argue that. I mean, it's because it really is a condition of mind caused by a mental disease or defect. And so that's what the doctors are going to have to sort out. Right? Every person is presumed to be sane. So that's where we start. Every person is presumed to be sane. Once the defense raises some issue with regard to the issue of insanity, and that means that it could be lay witnesses that they could call to talk about mental condition in this way. But once they raise any issue, the burden is on the prosecution to prove beyond a reasonable doubt that the defendant is sane. So it gets treated much the same as any other affirmative defense. So, for example, if the defendant raised the issue of self-defense, again, it's the prosecution then that would have the burden of proving beyond a reasonable doubt that this crime was committed without any self-defense. So the burden doesn't shift to the defense to prove innocence, to prove sanity, to prove any kind of affirmative defense. The burden is always with the prosecution to prove or disprove, as the case may be, beyond a reasonable doubt. Again, we talked about this issue of confidentiality, a plea of not guilty by reason of insanity or by placing his mental condition as an issue at the trial. That waives confidentiality as it pertains to the issue of sanity or mental condition. So in other words, whatever he says to the doctors during the course of, or whatever a defendant says to the doctors during the course of an evaluation, can be used against him by the prosecution or for him by the defense as it pertains to the issue of mental condition and sanity. So in other words, things that he said could not be used to determine guilt or innocence unless it pertains to the issue of the mental state necessary to commit those crimes. So that's why it gets confusing. And I was talking to I have a law student who actually recently sat on a trial with where the issue was sanity. And she said, there were these limiting instructions in terms of what can be considered, what can't be considered. And she said it makes it very, very difficult for the jury to be able to sort out, just because there's a limiting instruction in terms of what can be considered for one thing and what can be considered for another. John?
What about during this, if he goes for the insanity defense, does it then open up his medical record prior to the shooting with his relationship with Fenton, Dr. Fenton, and the other psychiatrists at CU, which would then, there's no confidentiality there either?
Well, and here's, so as far as and I'll get to that in a sec, so the examination can be done a number of different places. A preference is generally put on where the person is presently. So here the preference is that the examination be done at the Arapahoe County Jail, if it can be. If there's some circumstances that would make that difficult, then person can be transported to other places, such as Pueblo for the Colorado State Hospital. Evidence of confessions or admissions and other evidence, including medical and social history, may be used in forming the doctor's opinion about sanity. And that's where the issue comes into play in terms of medical history. And that is medical history. And the issue is going to be, again, is it non-cooperation if the the defense says, we're not releasing this past history in terms of his relationship with Dr. Fenton or what was said. One of the things that complicates this case, too, is there's still some outstanding issues. And one of them is the notebook, and whether, but for the raising of an insanity defense and an evaluation, whether the prosecution would ever see the notebook. One of the issues still has to do with how was that notebook disclosed, and that gets into some of the things that Steve will be talking about, but that hasn't been decided yet. The same with statements, made, and at what point was there confidentiality, was there not confidentiality? So there's still some issues that haven't been decided yet.
With regard to Fenton and regard to the other two psychiatrists, can they then be compelled to testify by the prosecution or the defense if you have a full-blown insanity plea, they go through this process? Can the prosecution then say, okay, we want all of the notes, and Fenton, you're going to come in and testify, because she may testify one way or the other. Obviously, if she thought he was insane, she didn't do anything about it. And secondly, if she didn't think he was insane, that certainly plays into the prosecution's case. Can she be compelled to testify?
I think the issue comes down to whether anything about her notes, her evaluation, was it used by doctors in forming an opinion as to whether or not the defendant was sane?
These doctors
who do the evaluation. Because generally, if whatever evidence that doctors have used in coming to their expert opinion, generally you can get that evidence in, and there's all kinds of evidentiary issues as far as should it be disclosed to the jury or not. but it makes it a much better argument if the doctor used those things in coming to his or her opinion. If it wasn't used, maybe perhaps because the defense still said, I'm not turning this over, then the issue becomes, okay, does the prosecution get to call that person then? And I think there's a strong argument that they don't, if there's still that confidentiality piece that hasn't been waived.
But if these doctors, let's say at Pueblo, they decide they want that information, and the defense says, we're not giving it to you, you can't use that to form your opinion, all right? Can the judge then compel them to give it, or will there be a huge fight over that?
I don't think the judge can compel it, particularly if it was still protected. The issue becomes, is that then considered non-cooperation? And does that preclude the defense from being able to call witnesses on their behalf about the defendant's mental condition or the issue of sanity? I think that it gets more in terms of the issue of non-cooperation than it does compelling that evidence be used. That's my opinion.
So, if
All of this is my opinion.
if the notebook and if notes, whatever evidence from Fenton, are used in the court-ordered evaluation of his sanity, then that material is available to the prosecution. Is that just in the penalty phase?
That material would be available to the prosecution in the sanity phase,
Okay.
right? And any place where his mental condition is being raised. So, for example, in the trial itself, in the trial on the merits, if, say, there's an issue that his mental condition does not rise to sanity, but rises to this issue of could he form the specific mental state of intent, then it gets used in that portion. And if he raises the issue of his mental condition, perhaps as a mitigating factor, if this case is a death penalty case, then that information can be, I think, can be used there too.
And it wouldn't matter whether or not the court-ordered evaluation found him sane or insane? It could still be used?
Well, the evaluation, all that is you can have doctors on one side saying that he's insane, doctors on the other side saying that he's not. The issue comes down to the trial and what does the jury find in terms of that. So, the evaluations can go all over the place. It doesn't.
So the doctors could say he's insane, the jury could say no, he wasn't.
Right.
Karen, you've talked about phases. Is there actually a sanity phase separate from the trial,
No.
or it's
No.
in part of the trial?
Yeah, it's part of the trial. So it's treated like an affirmative defense. So if you say, let's suppose that the affirmative defense was, again, self-defense is the one that we know so much. It comes in, witnesses are brought in on either side, and the jury has to find that he is sane beyond a reasonable doubt.
If the feeling at both sides that he is likely insane, why would they ever bring it to trial, right? Often these things there's some kind of plea deal that eliminates the case, right?
Sure, and that's going to be the issue. There's going to be, I anticipate, more than one evaluation. First of all, I anticipate that the defense have already been doing their own evaluations and are probably still doing evaluations. And, then there'll be evaluations done by court-appointed doctors. The prosecution, if they want another opinion after they get one, court-appointed, basically either side can also request another one. I've seen some cases where every single doctor has said insane. And, at that point, then decisions do have to be made. And if the prosecution can't find doctors, anybody to say that he was sane at the time, then that is going to factor into decisions that get made. I mean, they have to think about that.
by not entering into a plea, not guilty by reason of insanity the other day, are they stalling? Is the defense stalling not to have to release those records that you're talking about? Once you cross that bridge, you have to give it up.
I think that there are, I mean, my opinion is I don't believe it's just a stalling tactic for stalling's sake. I think that in so many of their motions that the defense filed, the issue really had to do with this whole concept of non-cooperation as it pertains to the death penalty phase, and whether that could be used against him in terms of if he doesn't cooperate, however that's defined, does that mean that in this death penalty case, he's not going to get to call witnesses on his own behalf to talk about his mental condition? And is that constitutional? I mean, I really think that that's a huge issue. And the judge couldn't address it because the death penalty wasn't there. So, you know, what this procedure's done, it's kind of forced the hand of the district attorney, the fact that there was, you know, this arraignment still, and the judge went ahead and entered a plea, then that means that the district attorney has a certain period of time to indicate whether they're going to seek the death penalty. And then I anticipate that these issues are going to be raised again, whether they're raised as soon as the death penalty is announced, if it's announced, you know, death, or at some point down the road. So I think that this was a way of also kind of getting things moving, getting things started, because the defense has to effectively advise their client of all the possible ramifications of this plea. And it's really the defendant that has to make the decision on how to plead. I mean, that's one of the rights. Can defense attorneys sometimes enter a plea on behalf of their client? Sure. But they need to make sure that they advise their client of all of the possible ramifications. Well, because of this one issue, in terms of the death penalty, they weren't in a position to be able to advise them of all of the possible consequences, because the issue of how that possible non-cooperation could get used at the death penalty phase couldn't be even addressed by the court at that time.
And there's no case law, you say, that would guide anybody on
No, because we're not aware, nobody's aware of any death penalty case where it's been an insanity defense since 1999.
In the state.
In this state.
I've never heard, and this is something new for me, I've never heard in any, in other states that I'm aware of, that if the prosecution goes out and the state does an evaluation and says this person is insane, okay, and the state says that, the prosecutor's own, I've never seen a situation where the prosecutor tried to go in and overcome that in a trial. I've never seen that happen. Would that be, you know, unusual?
Well, I think that first of all, when we're dealing with the issue of individuals who are doctors looking at everything and making a determination of insanity, I don't think it's a all or, you know, what's the right word? I just don't think that you find typically doctors who agree on, you know, this issue all the way down the board.
I'm not talking about the defense.
Right.
I'm talking about I've seen cases where you have the state doctor say this person is insane, and for then a prosecutor to go out and say, okay, I got to shop around and find somebody who says he isn't, and you've got the defense, you know, obviously saying he's insane, and you've got the prosecutor. I've never seen a prosecutor try to go out and shop around and try to find something to overcome that. They've always pled. There's always been a plea deal. I've never seen that happen. Have you seen that happen? Has that happened before?
I don't, you know, I haven't seen it, but there's so few insanity cases. Yeah. And could I envision asking for a second opinion? Not necessarily shopping around, but just getting a second opinion. Absolutely, on a case like this, rather than just relying on one doctor. I mean, I think this is one where, you know, you would want other opinions with regard to this issue.
I have a question about the non-cooperation. The defense not wanting to release his previous medical records sort of makes sense to me, but would they say to him, like, don't talk to the state doctor, or are they afraid that he's just not going to answer their questions because he's insane, or, what's the non-cooperation with the doctor?
Well, and that's what they were asking. What does cooperation mean? With regard to this, and how is it distinguished in terms of, is the non-cooperation a manifestation of the disease or defect, right? I mean, those were all questions, that were posed. I mean, when we're talking about cooperation, it's kind of the way case law is defined, that is talking to the doctors. And I think that, I don't believe that they would advise their client, don't talk, don't cooperate. I think the issue may be is they may not know exactly what's going to happen when their client gets to that evaluation. And so what they're trying to do is kind of know all the ramifications so that they can advise their client of, here's what's going to happen down there, and here's what happens if you don't cooperate.
Well, if they are already seeking evaluations, which I would think they would be, they must already have an indication of whether he is cooperating or not.
I don't know. I don't know. And I don't know how far those evaluations have gone. If the evaluations, are at the point where people are talking to their client, or if they're reviewing other information that they have, talking to the parents, I don't know.
Right. Well, just the fact that they seem to be so concerned about the non-cooperation.
Well, the
would lead
concern
one to
about the
think-
non-cooperation is you can have that concern if you don't know.
Right.
And and you've got this death penalty issue
Right.
of, okay, if my clients don't, does that mean,
Right.
the jury gets to decide without hearing all these witnesses to talk about his mental condition, and they get to decide life or death without hearing
Right.
any mitigation with regard to that? I mean, that's a huge issue. It's a big issue.
Can I ask about competency for a second? You said it can be raised at any time. In the Jared Lee Loeffner shooting down in Tucson, that was the issue, and the case got postponed for, I think, a year, and then they ended up with a plea. Is it the fact that he's able to, that his defense counsel represents that he's able to consider which plea to enter, and that they didn't say, well, we can't even talk to our client and figure out what plea to enter. Does that undercut a later raising of a competency argument?
No, I mean, first of all, I don't know if he's on any medications now. I don't know what's going on, but I've seen cases where things are progressing, and then right before trial or during trial, it's clear that the person is not able to see what's going on.
And then I have one more question. With regard to Dr. Fenton's notes that I don't know whether the prosecution has them or not, because we don't have the details of what production orders have been issued. But we do know the notebook is in the court's possession, and the prosecution took off the table the issue of privilege and said they were doing so because at some point they anticipate mental health would be placed in issue. At that point, there'd be, as they explained it, a blanket waiver, and that notebook, whatever is in that package, would no longer be subject to the doctor-patient therapist relationship. Is that correct? So once he enters NGI or places his mental state in issue, the notebook does go into the prosecution has access to it?
I think that notebook is still an issue, and I think that also gets into the issue of cooperation, because it hasn't been ruled that that notebook isn't privileged.
But
Right,
doesn't the privilege get waived once he? I mean, that's what
Well-
I read the advisement very quickly, and it seemed to say that.
I get the sense that it's the privilege as far as any statements that he makes during the course of this evaluation. I don't read it so broadly to say that anything that he's ever said, because what it says is the doctor may look at admissions, confessions, social history, medical history. This would be medical history. I'm not sure that it's so broad as to say that it waives every privilege that he has with regard to any doctor.
But are you saying that if the doctors at Pueblo say, no, I want to see that notebook, all right, once they see that notebook, and that's part of the medical history, I mean, that's now, that's what I think you're asking, isn't that a waiver? Because now they've considered this, and then the prosecution would have the opportunity to say, okay, what did you look at?
Right. I think the issue is the defense required to turn over that notebook during the evaluation? Just because they said, I want to see the notebook, I'm not sure it's required, but I think that it could be used as non-cooperation.
Right.
If there's a refusal. But yeah, once it gets turned over, then again, the doctor's considering it in the course of deciding the evaluation. I'm just not sure that it's going to be mandatory, that it has to be compelled to be turned over.
But then you're saying that could be a linchpin because non-cooperation is undefined in case law. So therefore, that could be, I mean, we could be getting into so many hearings over so much minutia, well, not minutia, but each point of whether the judge would have to rule, if you don't turn over this notebook, is this non-cooperation under the statute or is it not?
And that's what
So-
the defense was asking for,
Yeah.
is help us understand what non-cooperation means.
And the judge is basically saying, okay, let's do it case by case by case by case, right?
Right. So it's going to go on for a while.
Yeah.
So,
As more and more time passes, we're now at 9 months or so, how hard is it to get back to what his mental state was back at last July versus now, especially if he's been on medication, if he's had time for it all to sink in, if, all of these things happen?
well, and that's why anything historically, I mean, the doctors would have access to all the information, all the discovery pertaining to the night that this happened, all the police reports that were made, I mean, any interviews that they did with, for example, people up at CU, of, people who knew what his mental state was like around the time, what his statements were to the police afterwards, police officer statements. So there's a lot of information about what his mental state was at the time. And that doesn't change just because there's been more time. And that's why the doctors want to look at any kind of social history, anything that's out there. Are there school records out there? Are there other mental health records, like in this case, that are out there? But, it's not that uncommon in an insanity case for doctors to be having to go back in time. But fortunately, there was a lot of information put together at the time that this happened that the doctors would be able to use.
Have you ever seen a circumstance where the defendant actually will take the stand during an insanity defense?
I haven't personally had that happen, and I don't know, if it has happened. I mean, I could see it happening, but I'm not aware of that situation. Insanity cases are really rare. It's a defense that doesn't get used that much because people know, defense attorneys know, jurors don't like it. And also, you start by the fact that, yes, my client did it. Yes, I'm guilty. I did this act, but I was insane. So you're kind of, taking every other defense off the table.
Do you think the prosecution, given the entry of the plea by the judge, prosecution has really no choice but to go for to put the death penalty on the table because they can't take it off later? I mean, they could take it off later in a plea, but they have no choice but to put the death penalty now on the table. I mean, it's forced their hand to do that.
The defense has to make the decision within a certain period of time.
The
Prosecution,
Yeah.
whether to seek death. And they can always take it off the table down the road. Just like the defense can always withdraw a plea of not guilty by reason of insanity down the road, if they chose.
So if a defendant pleads not guilty by reason of insanity, it is in fact an admission that I committed the act, but I was insane at the time?
That's really what it is, yeah, absolutely. Because you're saying I did it, but I was insane, as opposed to I wasn't there and I was insane, right? So, but what you're saying is I'm not guilty of this because I was insane at the time I did this.
But you said that they could also withdraw that plea.
Mm-hmm.
But if you withdraw that plea, if you make that plea to begin with and then you withdraw it, then can't that be used in court against you as,
No, not that you pled one thing before. Mm-mm. All right. We talked about this issue of narcoanalytic drugs and polygraph may be used. And I was talking to a friend of mine who's been doing criminal defense for like 40 years. And, I was asking him, I said, have you ever seen the state use this? And, he said, no, it just, it doesn't come up. And in talking to other doctors, it's one of those tools, as I said, this was in the statutes way, way back when doctors didn't have near the number of tools that they have now in terms of trying to determine, does somebody suffer from a mental disease or defect, and were they incapable of distinguishing right from wrong? So over the years, there's just been so many different tools. This was one of those things that was put in the statutes early on to be able to help doctors, make this determination. But in terms of has it been used? I mean, nobody's even been aware of whether it's been used by the state, and there's certainly no case law, which would suggest it hasn't, because I would think, given how long this has been in the statutes, if it had been used and had been an issue, somebody would have raised it, and we would have had some type of appellate decision with regard to it.
So you're saying it's never been?
I'm not saying it's never. I'm just saying that nobody is aware. Okay. Nobody's been aware over the years, who, particularly those people who've done criminal defense for 40 years, nobody's been aware of the state actually using these things. Not to say it hasn't, just the people that I know are not aware of it.
Has anyone raised the possibility that these techniques are now outdated, no longer valid as?
I mean, there's been people who have talked about that it's like, maybe just one of those things that should be taken out of the statute this time because it's not necessary anymore. But it's just one of those things that's just been there. And so when the changes got made, it really didn't change substantively in terms of taking out certain things. It added certain things as far as the non-cooperation, but didn't remove some of the tools that doctors have. So, it's there. Whether it means anything that it's there, I'm just not sure. And who knows even in terms of truth serum. It's like, what do we know about it? We know about it from TV. It's like they say, oh, yes, I did all these things, right? I'm not sure if you talk to doctors whether they would say that these types of medications, really are effective at making somebody tell the truth, or perhaps it's, helping with the person's memory, whatever it is. But the reality is we just haven't seen it be used.
But if he's already admitted it, he's going for a sanity defense. Why? You don't need the drug to prove that he did it. He's already admitted it. I did it. So.
I have the same question. Why?
Yeah,
Well, and that's. Yeah, that's why it's been in the statute for years and years, since 40 years or so.
Wouldn't that more be a tool to, rather than did or didn't he do it, what was his mental state at the time? I would think it would be to keep a subject from faking insanity.
Or if somebody says, yeah, I blacked out, I have no memory of this, and maybe, with this medication, you can find out more, or with a polygraph, in terms of, do you really not remember anything?
It feels like the notebook has to be admitted because it goes to intent, it goes to what he's thinking, it goes to his evaluation back at the time of the.
Oh, the doctors are absolutely going to want that notebook, and that's going to be, I think, hugely helpful for them. But again, keep in mind that that's not going to be dispositive of whether he was insane. His writings could have been crystal clear. But that doesn't. That's not the end all in terms of, does he suffer though from a disease or defect that makes him incapable of distinguishing right from wrong. We talked about this issue of cooperation, what cooperation is. A finding of not guilty by reason of insanity results in commitment to the custody of the Department of Human Services until such time as a person may be released. And we're done. There's no, even if the death penalty is on the table, there is no death penalty. And when we talk about a finding, we're talking about a finding by the jury, or a stipulation between the parties that the defendant was insane at the time.
Just because we're talking about this case all morning long, and this is why we're doing this in the first place. Is it possible, does the defense really think that this jury here, or anywhere in the state of Colorado, it will possibly find him not guilty by reason of insanity? I just don't see that happening. I don't think it's possible.
Well, I don't think that people can make that determination until you have evaluations. And I mean, we know that there's a mental health history. We know there's issues. Until we see from people who have the expertise in making that determination, I don't think anybody can guess whether or not a jury would find him insane or not. I think that you have to look at what are the evaluations? What do the evaluations show? And until we know that, until we hear from people with that kind of expertise, I don't think we can speculate on what a jury's going to do or not do.
I don't know. I guess I'm just thinking that the jury is human, and looking at what he's done, it's probably going to be incredibly difficult to listen to a bunch of doctors and say, well, okay, that makes sense, and weigh what the testimony is versus what the proof.
Well, and that gets into the issue of jury selection. And, it's going to be tough to get a jury, but I believe in the jury system. And I believe that people take their jobs seriously. And the issue isn't whether people heard about what happened. The issue is going to be whether people have already made up their minds before they hear medical evidence, before they hear anything that comes from the jury box. And if people have already said, I know he's saying there's no way I could do otherwise, regardless of what the evidence is, those people aren't going to end up sitting on a jury.
And will the jury know this? Will they explain to the jury that your choices are either prison, death, or a possible release at some point when he's cured?
They generally, in terms of the finding of not guilty by reason of insanity, they don't know. But with regard to the death penalty, there is an instruction that they're given that says life imprisonment means life, the rest of their natural life, so that they know that life doesn't mean 20 years or 40 years or whatever.
What instructions the jury is given when it comes to weighing whether or not someone was insane at the time?
Basically, these definitions, and that the prosecution has to prove beyond a reasonable doubt that the defendant was sane. I mean, kind of exactly what the instructions are. I mean, credibility of the witnesses is the same. They can determine they decide who they believe, what weight to be given that person's credibility.
Do the plea of not guilty by reason of insanity, can we assume that they have at least one doctor who agrees that he was insane at the time?
I don't think you can assume anything. And I've actually seen trials where there were no experts saying that somebody was insane at the time, but the defense went forward anyway. And the jury had to really consider it, because you have a lot of people where, when you see particularly these types of heinous crimes. I mean, I had one case where it was an issue where it was a child abuse death. And what this mother did to the child was just horrendous. And there was no medical experts other than ours. But the jury was out for hours, and they said, we just couldn't get past the point of how somebody who was really sane could do these things to her own child, right? And so, you deal with kind of the fact that jurors are human beings, and how many people think, of course, somebody's got to be insane to do this, right? So, and you can present lay witnesses in terms of a person's sanity, all kinds of things. So I just don't feel like we can presume anything in terms of if there are no doctors saying that the defendant's insane. Right?
The same jury that might determine that he was sane at the time, would then be asked to determine the sentencing and be asked again to consider mental state. Is that how it would work?
They would consider, right, and then again the issue becomes into play as far as, and I think we're done with sanity, so let's talk about the death penalty. Death penalty, so unless a person is convicted of a Class 1 felony, then the death penalty can't be sought. So again, if there's a not guilty by reason of insanity finding, there can be no death penalty. If there's a mental condition and the jury finds, well, it's second-degree murder, we're going to not find first-degree murder. Again, then we don't go forward with the death penalty. So there has to be a conviction of a Class 1 felony. Person has to be 18 years of age at the time, and we don't execute mentally retarded individuals. Same jury decides guilt or innocence, including the issue of sanity. What we do procedure-wise, we do what's called death qualifying a jury. And the idea is when we do jury selection, we're looking for individuals who are so opposed to the death penalty that regardless of what the evidence is, they are not going to find the death penalty under any circumstances. And so those people would be excused. So jury selection in death penalty cases take a long time. Jury selection in this case, I think, is going to take weeks because there are so many issues besides the death penalty as far as pretrial publicity. But in any event, before you even get to other issues in the case, you do this idea of death qualifying a jury. As far as the death penalty sentencing, so what happens is if the person is convicted of a Class 1 felony, you go to the next phase, which is kind of a trial. And it's the time where the prosecution can call witnesses, the defense calls witnesses, and the judge can hear all kinds of evidence as long as it's relevant to the nature of the crime, the character, background, and history of the defendant, matters relating to any of the aggravating or mitigating factors, matters relating to the personal characteristics of the victim, the impact of the crimes on the victim's family. If a defendant, let's say that there hasn't been a mental health evaluation already. When we get to the death penalty phase, if the defense wants to raise mental condition for the death penalty, and this would be determined, well before the actual trial, then the court can again order an evaluation with regard to the mental condition of the defendant. So prosecution and defense can make opening statements, closing arguments for or against a sentence of death. The jury is instructed that life imprisonment means imprisonment for life without the possibility of parole. During deliberations, the jury has to decide, there's like a 3-step process. The jury has to decide whether at least one aggravating factor has been proved beyond a reasonable doubt. The next step, and if they haven't found that, then they're done. Whether sufficient mitigating factors exist which outweigh any aggravating factors, and whether the defendant should be sentenced to death or to life imprisonment. A death sentence has to be unanimous. If it's not, then it's going to be a life sentence.
What are the aggravating factors? Are there several?
Let's go, yep. Aggravating factors. You knew what my next slide was going to be. There's tons listed in the statute of aggravating factors, and what I did was I kind of bolded put in bold some of the factors that could be considered aggravating factors in this case. So the defendant committed the offense while lying in wait, used some type of explosive or chemical, committed a Class 1, 2, or 3 felony in the course of or in furtherance of such immediate flight therefrom, intentionally caused the death of a person other than one of the participants. In the commission of the offense, the defendant knowingly created a grave risk of death to another person in addition to the victim. The defendant intentionally killed a child who has not yet attained 12 years of age. The defendant intentionally killed more than one person in more than one criminal episode. So there's a number of different aggravating factors. The mitigating factors, there's a lot of mitigating factors. The ones that would probably be the most relevant to this case is the age of the defendant at the time of the offense. And here's where you get into the mental state issue. The defendant's capacity to appreciate the wrongfulness of his conduct, or, and then it goes on kind of to talk about the issue we talked about of mental impairment. The absence of any significant prior conviction would be another. And then you get this all-encompassing one. Any other evidence which in the court's opinion bears on the question of mitigation. Questions?
When you said that the defendant had to be 18 at the time of the crime?
Yes. Yes. So juveniles are not eligible for the death penalty even if they're filed on as an adult. That's the SIG case. All right, I'm going to turn it over to Steve.
Let me ask, before you take that up, let me ask you a sort of a recasting of Anastasia's question. Not how is it possible that a jury could find? I know we are hesitant to predict how juries or judges are going to rule. But are you aware of any case where, and I know there aren't that many NGI cases nationally, but where there's been a series of planning steps over the course of weeks and months? I think that's essentially what, where it wasn't a single snap, a single event on July 20th, but there was a lot of preparation and deliberation, as the prosecutor or the Chief Oates has said. Are you aware of any case where a not guilty by reason of insanity was sustained given that course of conduct?
I haven't seen any cases where there's been that kind of course of conduct. And so, to say that there's where insanity has been raised. So I don't think, I could say that.
It's a pretty small set of cases, though, right?
Yeah.
Right.
I mean, I will just tell you about one case. I remember when I was a prosecutor that there was a finding by everybody that this woman was insane, where she did take steps. I mean, she ended up slitting the throats of her 3 children, and she had. This is a woman who, by everyone was like, mother of the year. I mean, basically, she was a single mom. Took care. These kids were clean. They were well behaved, spotless, everything. Neighbors talked about seeing her, pushing her kids. Her electricity had been turned off. She lost her job. Everything. And so in her mind, she made this decision that she was going to kill herself. But she believed that she would be a terrible mother if she left her kids. And so she decided that she was going to take her kids with her, because then she would be a good mom. And so that was, her state. And, went to the state hospital. Again, never had been nothing. But it was planned. Went to the state hospital, and the doctors all found that she was insane at the time. And so there was an agreement reached between myself and the prosecution that she would go to the state hospital. But so that's the closest I can think of in terms of planning. But that, in her mind, that was how she saw this. So every step that she made was to kind of take her kids with her. It wasn't just a snap. So
the other factor that seems to be in some of these cases is that victims have to testify. So if a prosecutor goes to victims and they say, we just can't do this, it's going to have an issue.
What do you mean?
Well, I've seen death penalty cases where what has prompted a plea is that people have been so traumatized that they just don't want to go through the trial. The victim says, I can't do this. Or a police officer can do it, but the victim is saying, I can't go in here and relive this theater thing, or I can't relive this, and that has helped the prosecution come to a plea of life in prison without.
I'm not sure that it's about can't get through a trial, because they're going to have to testify most likely on just the regular trial. I think for a lot of the victims, it's also a matter of having some finality in terms of this process. We're seeing cases that are now 14 years out. There was another case, Chuck E. Cheese case, where one of the victims did not want the death penalty because that was a value that one of the parties who had been killed believed. They did not believe in the death penalty, and she did not want to change that value because of what happened. So there's a number of reasons why people don't want to go through with it. But I'm sure, the problem with this case is you have so many victims, so many families of victims, all who are going to have differing views, and it's still the decision of the prosecutor as far as what to do in this case.
Good morning. You all know me. I've been representing you in the Aurora theater shooting case. I want to I welcome the opportunity to talk to you about the law of access. As I understood it, this was law school for journalists, and you know that we've been filing lengthy. They've been critiqued as overly lengthy pleadings on your behalf, setting forth the law of access, but I'm not sure that any of you have bothered to wade through them. So I wanted to just really do what I understood the mission was here today, to talk about the law under which we go to court on your behalf to gain access to both proceedings and to records of the court. And like Karen, I need to say that I'm not here representing any of you, and my comments are my own opinions, and not that of any client. So I want to just start. I'm going to talk about three things. What is the source and scope of our right when we show up as the press? And really, it's the right of public access, not the right of press access. Which proceedings does that right attach to? And then looking at some of the records that we have fought and continue to fight over, not only in the Aurora theater shooting case, but in other cases as well. So starting on source and scope of the right, if this is law school, then it should be Socratic. So how many of you know why we have a Freedom of Information Act, both federally and at the state level? Does anyone know why we need a statute if the First Amendment guarantees our right of access to records that tell us what our government is up to?
Because, on the state level, it has its own boundaries of what's public and what's not public on the state level. So you need that state statute on the state level to discern what's disclosable to the public.
Right. It's true that the state statute is different than the federal statute, and the federal statute doesn't apply to state agencies. So those of you who do FOIA requests from the Air Force Academy or Fort Carson or any federal agency up here know that you can't use the Federal Freedom of Information Act to get DORA records or any state agency records. It applies to federal agencies, not state agencies. So you do need a separate state statute for access to state agencies. But if we have this First Amendment, right, our right to know comes from we the people, in order to be self-governing, need to have access to information about what our government's up to. Why do we need any statute? Right? Why can't we just go in and say, I want to see the governor's cell phone records or whatever records we're interested in under the First Amendment?
Because of the sovereignty of the state of Colorado, because the state has its own constitution.
All right, again, the different state, federal issues are valid. But the real answer I'm looking for, I'm not going to call you out by name, it's not really law school, is that the Supreme Court hasn't recognized a right of access in the public to access governmental information in two of the three branches. So let's go back to Civics 101 for a second. We have a legislative, judicial, and executive branch. Thus far, the Supreme Court of the United States has not recognized a right of access under the First Amendment in the public to access legislative or executive branch agencies or records. We assert that right all the time, and lower courts all over the country have differed on the scope of that right to witness an execution down the road, or Chuck E. Cheese, I guess, would be next up. The right to attend an execution goes on in an executive branch agency, right, the Department of Corrections. limited rights of access under the First Amendment to the executive and legislative branches. Of course, everyone understands and believes we have a right to see Congress in session, and we have a right to see the General Assembly in session. But the reason we have Freedom of Information Act is to fill in that gap, to create a statutory right of access to records in the hands of government agencies other than the judiciary. Now, in Colorado, our state statute applies as well to the judiciary, and in fact, when I talk about records, court records later, our Supreme Court has looked to our Criminal Justice Records Act as the basis for providing access to our state court criminal files. We've maintained, and there's a good body of case law throughout the country, that the First Amendment does provide a right of access to judicial records as well. But thus far, the Supreme Court of the United States has only determined that there's a right of public access to judicial proceedings. It's never even addressed the issue of access to judicial records. In one of the cases, there are about 6 or 7 of the cases now that have gone up to the Supreme Court about access to judicial proceedings. I feel like Mark Rubio here. They did say that there was a right of access to a transcript of voir dire, the jury selection. So there was a record involved there, but it was a record of the proceeding, so it's a little unclear. Again, courts throughout the country have recognized a First Amendment right of access to judicial records. But so far, and this is the other sort of mind-blowing fact I find, it wasn't until 1980, which in my mind is not that long ago, that the Supreme Court of the United States first recognized a First Amendment right of access to judicial proceedings. Think about that. 1980. A case called Richmond Newspapers against the state of Virginia. And the Supreme Court in that case held that the public, remember, when you all go to court, you're going as John Q. Public, not ABC, NBC, or any other lofty of the press. The First Amendment does say Congress shall make no law abridging freedom of speech or of the press, but for all intents and purposes, that last phrase is sort of a nullity. You're going as a representative of the press, of the public, and have no greater rights, no lesser rights either. The Colorado Supreme Court did hold in 1979, in a case involving a preliminary hearing, that it was unconstitutional to bar the press only, but to allow the rest of the public to attend a preliminary hearing. So the press has coextensive rights with that of the public, no greater, no less. So in 1980, the Supreme Court said that the public has a right to attend criminal trials under the First Amendment. So that's the source of the right, and it applies to judicial proceedings, and as I said, lower courts have applied it as well to judicial records.
Has the Supreme Court ever ruled against public access to records of the executive or the judiciary?
I don't believe it actually has, so I don't believe it's been determined that there is no such right, but there were cases, and I'd need to look at those, the Houchins KQED cases about access to executions. There have been a series of cases about access to executions, so I'll get back to you on that. They haven't definitively rejected it, as to my knowledge. So the Richmond case said that there was a right of the public to attend trials. Now, no right is absolute. The First Amendment, you can't falsely shout fire in a crowded theater. You can't publish libelous statements with reckless disregard for the truth, etc. So no right under the Constitution is absolute. And the right has to be balanced against other rights, including those under the Sixth Amendment for a defendant's fair trial. And as well as other rights of privacy, of rape victims, and other victims. So the court has balanced those rights, and I'll talk about the test that is applied in balancing those rights in a second. But first I wanted to jump down to which proceedings? Are all proceedings subject to this public right of access? And the answer is no. Grand juries are secret and conducted in secret all the time. Sidebar conferences that go on in court every day, where counsel meet with the judge at the bench, and they put in a sound dampening white noise device so that the jury and the public can't hear. Jury deliberations are conducted in secret, and there's no First Amendment right of access. But the court has extended this right of public access, a presumptive right of public access under the First Amendment, to other proceedings, not just the trial. First of all, to the voir dire portion of a trial. It is part of the trial, the jury selection. And in a series of cases, the court has found that First Amendment right applies. And most recently, in the most recent set of United States Supreme Court cases, said that a judge must independently consider alternatives to closing a jury selection, even if no party suggests such alternatives. It's also extended that right to suppression hearings and to the preliminary hearing, as we recently went to court here in this state over the Austin SIG preliminary hearing. So what are the requirements? How do we decide which proceedings are subject to this right and which are not? The Supreme Court, in that Richmond newspapers case in 1980, stated that there's a two-pronged test, basically history and function, or tradition and function. There has to be a long-established history of access to a particular proceeding, dating back to, say, the founding of our nation, and the openness of the proceeding to public scrutiny actually furthers the function of that process. And history has sort of taken a back seat in more recent cases because there are more recent developments in criminal process, much like Karen was saying. The procedures that are used and the hearings that are used in criminal cases continue to evolve, so the courts aren't as wed to a strict tradition analysis as they initially announced. But on the issue of function, here, it is our argument that with the exception of the grand jury, which is an investigatory body, and jury deliberations where we want them to be candid and the jurors to speak their mind and work through analyzing the facts in the law, by and large, probably the best statement of the function of openness comes from Justice William Brennan in a case involving a prior restraint in a criminal case, Nebraska Press Association. Justice Brennan wrote, "Secrecy of judicial action can only breed ignorance and distrust of courts and suspicion concerning the competence and impartiality of judges. Free and open reporting," what you do, "criticism and debate can contribute to public understanding of the rule of law and to comprehension of the functioning of the entire criminal justice system, as well as improve the quality of that system by subjecting it to the cleansing effects of exposure and public accountability." He was a pretty good writer, Justice Brennan. And that's generally the view, that the reason we have open judicial proceedings is because it keeps everyone honest. The judges, the witnesses, the prosecutor, the defense counsel, everyone. So there's helping promote the truth-finding function, and then there's the function of letting us, we the people, through you and your reporting, know that the process is working, and avoiding that suspicion and distrust that comes inherently from closed Star Chambers sessions that predated the founding of this country. And then there's also a cathartic effect when there's a horrific crime, whether it's Aurora or Austin SIG and numerous others that Karen has recounted for us, that knowing that justice is being done. So what are the procedures and standards for closure? As we found in the Austin SIG case, the procedures are almost as important, I would say equally as important, as the substance. Before a judge closes a judicial proceeding to which this First Amendment right of access attaches, or seals a file, or a portion of a file, there has to be basically due process. And due process for those of us who enjoy the right of public access, which means any member of the public, is notice and an opportunity to be heard. In the Austin SIG case, the court may have provided sufficient notice. It had let people know in a series of proceedings that it was contemplating closing the entire preliminary hearing, and then in December, I think December 12th, announced that it was going to do that. We demanded for you all in a petition that order be reconsidered. We asked for an opportunity to be heard. And the case law is pretty clear that before closing a judicial proceeding, judges really ought to give members of the public, and you all serve as their surrogate, members of the press an opportunity to object to closure and have one of your attorneys argue against closure. That didn't occur in the SIG case. The second thing that has to happen is that there have to be findings made that justify closure, that the constitutional standard has been met. And those findings have to be expressed, specific, on-the-record findings so that a reviewing court can decide whether or not the constitutional standard has been satisfied. And that standard, now getting to the substance, is a two-pronged test. And the reason we have a standard for closures, as I've said, the First Amendment right of access is being balanced against other rights. It's not an absolute right. We don't say, well, the First Amendment attaches, this is a trial, it's a preliminary hearing, we have a right to be here, it can't be closed. That's not true. It's not an absolute right. So the court has, in a series of cases, balanced competing rights, including the Sixth Amendment rights of a criminal defendant against the First Amendment rights of the public. And so the test that must be met before a proceeding can be closed, and we argue as well, a pleading can be sealed, is there has to be substantial probability of harm to a defendant's fair trial rights from openness. Substantial probability of harm to the fair trial rights of a defendant or some other compelling governmental interest, including privacy rights of victims and things of that sort. And it's a two-pronged test. Both have to be met. And there are no less restrictive means available to adequately protect that interest. Both prongs must be met. And the less restrictive means, what does that mean? It means things other than closing a courtroom, other than denying the public the right to know how our government is conducting important governmental business. And so that includes the full panoply of prophylactic measures like moving the trial to a different jurisdiction, weeks and weeks of voir dire before you move a trial to a different jurisdiction. I mean, you can think of some of the high-profile cases even here in Colorado with the Oklahoma City bombing trials, where there's been massive publicity even on the eve of trial. You may recall, a month before Timothy McVeigh's jury was called to court to be seated, it was widely published throughout it was the early days of the internet, so it wasn't sort of the same 24/7 news cycle we're living in now. But there was CNN. It wasn't that long ago, 1996. And a month before the trial, it was widely published that Timothy McVeigh had timed the attack on the Murrow building in order to maximize the body count, including kids in the daycare center in the Murrow Center. That was everywhere. Front page, Dallas Morning News, it was banner headlines everywhere. And only half of the jurors who were questioned to be seated at Timothy McVeigh's trial were aware that that had happened. In a large metropolitan area like Denver and surrounding areas, I would say in Jeffco as well, it's almost impossible that you can't find 12 jurors who, believe it or not, are unaware of many of the details that you all are living and eating and breathing, and all of us who are news junkies are consuming all the time. And even and complete ignorance is not the test. We seat jurors who have been exposed to publicity, not just because of what's in the court file, of course. Most of, 90% of what you've all reported, particularly in the Aurora Theater shooting case, came from information outside the court file, particularly in the early stages when the entire court file was sealed. And it's not the test that we have jurors who are completely ignorant of the facts or what's been reported. Karen was talking about a lengthy voir dire process in this case because of all the information that's been published, and that's true. But that's the society we live in. There are other countries who do bar the press from reporting on crimes until after a verdict is rendered, and that's not our constitutional system. We don't shield all of the public in order to find 12 jurors. We find 12 jurors, but we the people are allowed to know what our government is up to. So there's a whole panoply of alternative measures, including moving the trial. We have prosecutors and others who say, well, we have to close this hearing because otherwise we're going to have to move the trial. While that may be a decision that they would like to make and some people would like to make, the Supreme Court has told us that's not a choice for government to make. There is a prioritization of rights, and the reason why the second prong of the test is no alternative means are adequate to protect, let's say, the defendant's fair trial rights, is to make it very clear that we don't close a proceeding in order to avoid moving a trial. We move a trial if that's what we have to do after we've had a proceeding that's been open. It's unconstitutional to close a proceeding in order to avoid moving a trial. So those are the findings that must be met before any proceeding can be closed. I've given you some materials, it's law school for journalists, but there's no exam, and I've given you in the materials by digital the order of the Supreme Court entered in the Austin Sigg case a couple of weeks ago. And what the court said in that case was that the order closing the proceeding did not make specific findings demonstrating substantial probability the defendant's right to a fair trial will be prejudiced by publicity that closure would prevent, that's prong one, and that reasonable alternatives to closure cannot adequately protect the defendant's fair trial rights, as required by one of these later cases after Richmond newspapers, one of the two press enterprise cases. This press enterprise case was specifically about a preliminary hearing. And there have been two other Supreme Court cases applying the First Amendment right of access to preliminary hearings since then. So that is the test. It was applied here properly by the Colorado Supreme Court in ordering that the Austin Sigg proceeding be open unless the appropriate findings were made. Judge Munsinger didn't make those findings, and the entire proceeding was open, and we learned an awful lot about that case. Oops. So let's turn for the last 2 minutes to records, and then I'll take some questions if there are any. Access to court records, as I said, we have argued, and numerous courts throughout the country have found that the same right of access to proceedings applies as well to judicial records. Our courts here in Colorado have not firmly embraced that case law. We tried to get the Colorado Supreme Court to embrace that case law a few years ago on behalf of the Associated Press. If you remember in the Aaron Thompson case for the death of Aaron A. Thompson, and the indictment was sealed, and we took that case up to the Colorado Supreme Court on another emergency petition asking that the indictment be unsealed under the First Amendment. And instead, the indictment was unsealed, but the court relied on our Criminal Justice Records Act, which says records of official action must be open, and the indictment is a record of official action. So it sort of dodged or didn't decide the First Amendment, Sixth Amendment balancing that we had hoped it would in that case. The judge in the Aurora Theater shooting case, as you know, sealed the entire court file upon request of the prosecution in the early hours of July 20th. And we've had a series of motions on behalf of the press to unseal the court file. The first of the motions asked the judge to unseal the docket, or as we call it here in Colorado, the Register of Actions, which, as you know, is the index of pleadings. It tells you what's on file, not the content of what's on file, sort of the table of contents. And the judge did immediately unseal the docket when we asked him to do so. The pleadings took a little longer. They weren't unsealed until September 21st, about a month after the shootings. And then subsequently, further unsealing occurred in late October. The first set of unsealings documents were heavily redacted, and we asked on behalf of the news media to eliminate some of those redactions. And to a large extent, that has occurred. I've put in your materials a couple of examples that show we haven't been completely successful in this regard. People's Motion 29 was filed on October 29th, after that October 25th unsealing, and it was then ruled upon by the judge on October 31st. We know because that was the proposed order. Here's the order. It was ruled on, as you can see, it's the order already People's Motion, and it was ruled on the 31st, signature and date, and we just don't know anything about what this motion is, what it sought, what it's for, was it granted, was it denied? You tell me. I've also put in the docket, the Register of Actions, for these events, and there's nothing to be learned from them either. It just says People's 29, redacted as per the instructions of the court. So the file's been unsealed, but there are still portions of it that remain sealed. And then, the issue of doctor-patient privacy remains at issue. I didn't put it in your packet, but Dr. Fenton's client summary, which was also unsealed. It has the headings. So it does note, psychiatric history and dangerousness categories. And you can sort of read tea leaves into this, and I know a number of commentators have. But this isn't being redacted because of, we don't know what's in P29, but this is being redacted because it's doctor-patient privilege at this point until further proceedings indicate otherwise. So there's still a lot of redaction. The other items that remain under seal at this point are the affidavits of probable cause, which we frequently go to court on your behalf if they are sealed. It tends to be in high-profile cases. Routine affidavits of probable cause, I see a lot of shaking heads. You all know they're released upon apprehension of the arrest of a victim, of a criminal or suspect, accused, in every case, every day. I mean, the newspaper is full of reports that quote affidavits for probable cause in support of arrest and support of search. They remain under seal in this case. They remain under seal in Newton, Connecticut. There is a pending motion asking Judge Sylvester to unseal the affidavits of probable cause now that we've had a preliminary hearing and an awful lot of information has come out.
That recent motion, I noticed on Friday it said that the court was unaware of the motion that was filed, that you filed in January. Did the court just not see that motion and now they're going to start mulling over unsealing the affidavit again?
I inquired about that motion the day of the the arraignment, and was notified that the court had not received that motion. It had been filed on January 16th, and the court did indicate that it would be taking up that motion.
So maybe this week? Maybe a unsealing of the documents this week?
I don't think there is no timetable under which the court must act, and I'm not going to make guesses or predictions about how soon the court will. I would note that the people responded to that motion on February 5th. It was served on both parties. It was filed in the court,
but the court was just unaware.
Yes. In any case, so at this point they remain under seal, and we'll see what happens. The people's position, interestingly, the people were fighting the unsealing of those affidavits early on in the case, and maybe not so early on in the case. But when we filed our motion in January, the people's response was that the names of all victims should be redacted, and only the names of all victims, even those that have previously been published, which is a position they took and lost earlier in the case. But they're no longer saying that they need to maintain the ongoing investigation. So, at least they're on record that the only portion of the affidavits that should remain under seal are the names of victims. The public defender, Mr. Holmes, has not responded to that motion, but I believe he now will. Lastly, mental health records, picking up on Karen's remarks. There are cases throughout the United States, including the Ted Kaczynski case, the Unabomber, who had a competency evaluation in Montana, and that's in the Ninth Circuit Federal Court of Appeals. That court held that when mental health records become part of judicial and jury determination on issues, fundamental issues like guilt and innocence or competency, that First Amendment right of access that I've been telling you about attaches to those reports at that point. So, in closing, since we're right at the end of our time, I want to make you all feel good about what you do. I've said that you are only members of the public, no greater, no less. But the Supreme Court has said that the role of the press is an incredibly important one. Instead of acquiring information about trials by first-hand observation or by word of mouth from those who attended, people now acquire it chiefly through the print and electronic media. This was before the digital age, or they would have said so. In a sense, this validates the media claim of functioning as surrogates for the public. This contributes to public understanding of the rule of law and to comprehension of the functioning of the entire criminal justice system. That was, in fact, that Richmond newspaper's case from 1980. And I think it's still true that, as you all know, there aren't that many people who can make it out to Arapahoe County and Jeffco and everywhere else. And so you perform an incredibly important function in our system of government by providing people, the ordinary citizens, access to the proceedings through your reporting.
Can you touch on, I know we're almost out of time, the SHIELD law issue as it relates to the reporter that they're trying to get back here through subpoena to testify about how that reporter learned of the notebook and those kinds of things, and what the law is with regard to that?
I'll tell you about the law. So you all know that a Fox News reporter on July 25th reported that a package had been sent to CU to Dr. Lynn Fenton by James Holmes, and that the package had been inspected and that it contained a notebook and the contents of that notebook. And that same day, the defense counsel moved to sanction whichever government source, two sources were cited, for that information for violating the judge's gag order, as we refer to it, but his order limiting pretrial publicity. And since then, there was a hearing in December where they put on, I believe, 14 witnesses who testified only that they weren't the source for this reporter, and they didn't know who the source was for this reporter. That was the scope of their testimony. And so Judge Sylvester has issued an order to a court in New York to issue an order compelling this reporter, Jana Winter of Fox News, to appear on the first week of April when this hearing is set. My understanding is that on Thursday, Fox News appeared before a judge in New York, the judge who issued the order, and asked that it not be issued or that it be quashed. The judge denied that request, and Fox News is appealing that to a court in New York State. There is an issue about which state's SHIELD law applies. New York has a SHIELD law that provides an absolute protection for confidential sources. Our state SHIELD law does not. our state shield law, which has been reported as being weak. I actually think it's weaker than New York's, which has an absolute shield for confidential sources. Ours is a three-part test that requires any party wishing to force a reporter to disclose unreported news information, including the name of a source, to show that the information is directly relevant to a substantial issue in the litigation. It cannot be obtained from any other reasonable source, meaning you have to exhaust all other means of determining the information you're seeking, and that the interests in the party subpoenaing the reporter to testify or turn over notes outweighs the public's right to know and the reporter's right to inform the public. It's a balancing test under the third prong. So that is the law that applies. And I'm not going to opine about which state's shield law ought to apply here or whether either of them could possibly be met. So we've run over time. I'll take questions afterwards. Stick around, but I know you all need to go off to get back to work. So on behalf of Karen and myself, thank you.